asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is
no. My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution.
That was rejected. Well, let's be clear. Today's ruling should not come as a surprise to anyone. This was a long-shot argument. And while Trump's team will appeal to the Supreme Court, I would not be surprised if the court just didn't hear the case at all. And that would mean this Court of Appeals decision stands. The question now is going to be the timing. The former president, of course, slammed the ruling, saying in a statement, "The President of the United States must have full immunity in order to properly function and do what has to be done for the good of our country. A nation-destroying ruling like this cannot be allowed to stand, if not overturned, as it should be. This decision would terribly injure not only the presidency, but the life, breath, and success of our country. A president will be afraid to act for fear of the opposite party's vicious retribution after leaving office. I know from personal experience, because I'm going through it right now. It will become a political weapon used for election interference. Even our elections will be corrupted and under siege, so bad and so dangerous for our nation. Save presidential immunity." Joining us now, one of the smartest and fairest legal analysts out there, Sarah Isgur, former spokesperson for the Department of Justice under President Trump, attorney, ABC News contributor, host of the legal podcast Advisory Opinions. Thanks very much for coming on the program. Let's get this out of the way. This is not a surprising ruling, right?
You know, the only surprise is how long it took. I think we were expecting something within just a few days, maybe a week. This did take longer than we thought it would take, but not a surprise. It was an unsigned opinion, unanimous by the three judges, as you said, holding that no, a president does not have immunity from criminal prosecution after he leaves office.
All right, so the key question now is timing, right? So what happens now with regard to his trial?
Well, we have a lot of branching forks ahead of us, if you will. So first of all, remember that the Trump team does not want this to go to trial before the election. And so they've got several avenues to pursue here by right, basically. First, they're going to ask for all of the judges on the D.C. Circuit to now hear this case. Remember, this was a 3-judge panel. Now they're going to ask all, 15 or so judges to hear this. Even if the D.C. Circuit says, no, we're not going to hear this with everyone, there's a chance that, for instance, Judge Katsas, who's a judge on that court, could say, well, I want to write a dissent that we should hear the case. Well, first of all, he gets time to appeal it to the D.C. Circuit. Then there might be time for that judge to write the dissent. You're talking weeks, maybe a couple months on that process.
But Sarah, didn't this court rule that if he does that, right, if he doesn't go directly to the Supreme Court, and he tries to ask the entire appellate court to hear the case, that the trial process can then move forward? Meaning, they basically gave him a choice, saying, look, go to the Supreme Court, we'll put the case on hold. You want to ask us to have the whole Court of Appeals hear this thing? Well, then this case is going to move forward. So isn't that going to be part of the decision-making he's got to do here?
Right. So then he has another choice. He has 90 days to appeal this to the Supreme Court, like before he even has to file to ask the Supreme Court to hear it. Then there'll be a whole briefing process there before the Supreme Court decides whether to hear it. Or if, as you said, Judge Chutkan, for instance, tries to reschedule the trial date, he'll have the opportunity to then appeal that choice, basically, to seek a mandamus from the D.C. Circuit and then from the Supreme Court that his trial should be stayed until this other question is resolved.
So bottom line,
basically, they have a lot of options here.
I was just going to say, bottom line, it sounds like you're saying you don't think there's a chance that this thing goes to trial before the election.
Look, is there a chance? Absolutely there is. But the Trump team wants a delay. They have a lot of options for delay at their feet right now. Certainly, we're not looking at a trial. I mean, remember, this was scheduled for March 4th. Judge Chutkan's already said it's not happening then. We're not looking at April. We're not looking at May at this point. This summer would be the very earliest.
Right. And that's part of the reason I think that many are going to overstate the significance of this opinion, right? You're going to see a lot of people in a lot of media outlets who are saying, oh, you see, immunity's over, immunity's over. It's like, whoa, 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 whoa. Hang on. There's still a long way to go here. Even though you and I agree this is a long shot argument from Trump, that almost doesn't matter. This is all about running out the clock.
It was never about the substance of the prosecutorial immunity argument. It's always been about running out the clock. And remember, even if this goes to the Supreme Court, they could decide to take it on their so-called merits docket, meaning they're already full for this year. So that case would get scheduled for next fall, probably around November.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.